Welcome back. You never know what match will light what tinderbox, and I'm wondering if finally, the goal of racial and gender-based preferences in the name of equity or affirmative action will be buried once and for all, thanks to United Airlines. This week, United Airlines, seemingly named after the United States of America, issued this press release in the name of their CEO, Scott Kirby. Quote, "Over the next decade, United will train 5,000 pilots who will be guaranteed a job with United after they complete the requirements of the Aviate program. And our plan is for half of them to be women and people of color." Close quote. From Scott Kirby's Wikipedia biography, we learn that Mr. Kirby was raised as the oldest of 6 children in Rowlett, Texas. In high school, he played baseball and football and had aspirations of becoming a professional athlete. I wonder what his policy for United, if applied to professional athletics, would look like to Mr. Kirby. Should we turn the NBA, which is 75% African American, to 60% white to match our country's demographics, where only 13% of America is African American? Should the NBA become 20% Hispanic, where it is now 2%, to better reflect and match our community? And why aren't people arguing on behalf of Hispanics for equity in the NBA? And what about making the NBA 6% Asian American? As of now, it's 0.4%. Where are the advocates on behalf of the Asian Americans' representation in the NBA? It'll never happen. You know why? Because in America, athletes and their professional organizations take themselves seriously. They take competence and ability and effort seriously, and they are happy to make it unserious for every other institution in America, even at the expense of safety. It's not as if pilots on commercial airlines are vested with more care and safety for lives than professional athletes, are they? Or are they? So I thought it might be good for us to revisit some of these arguments we used to know. I should like to quote Carl Cohen at length. He is a professor of philosophy at the University of Michigan, an expert in ideologies like communism and democracy and fascism. He writes that affirmative action has long had many meanings. The ambiguity, sometimes deliberate, has muddled the discussion of the central issue, which is this: is there any justification for preference by race? The Civil Rights Act of 1964 authorized courts to take affirmative action to uproot racially discriminatory practices. That objective was and remains morally right. But by that same statute, race preference was forbidden. Affirmative action and race preference are thus plainly distinguishable. The former, in its original sense, is right and lawful. The latter is neither. Preference and affirmative action are widely confounded in the public mind because race preferences were introduced beginning about 1970 in the honorable name of affirmative action. What was to have been eliminated was given, in a complete inversion, the name of what had been conceived to eliminate it. Most folks today, with unintended irony, mean by affirmative action that very preference by skin color that affirmative action was designed to eradicate. The result is doubly unfortunate. Immoral practices fly the flag of justice, and policies that deserve support are tainted by association with what everyone sees intuitively to be unfair. Henceforth, let us be clear. It is race preference that is to be condemned. Race preference is not justifiable in morals or in law. Evidently only at United Airlines these days. Compensation to individuals who have been damaged is sometimes a demand of justice, but that is redress for injury, not entitlement by color. Skin color groups cannot be entitled to redress because rights are possessed by individuals, not groups. Race preferences are never just because they inescapably reward some who deserve no reward and penalize some who deserve no penalty. Race preferences are never benign because when goods are in short supply, to give to some by race is to take from others by race. The University of Texas, claiming to compensate minorities for wrongs earlier done to them by Texas schools some decades ago, gave preference to affluent applicants who had never lived in Texas and to foreigners who had never lived in the United States because their skin color was dark. For the race preferences commonly given today, the retrospective justification grounded in alleged compensation is almost invariably a fraud. The prospective justification of race preference based on an idealized redistribution of goods by race is wholly without merit. It supposes that absent racial oppression, attainments and advantages would be homogeneously distributed among all persons and all ethnic groups, a notion that is wildly false. On this view, the test for social justice is numerical proportionality among racial groups, impossible to sustain without perpetual social engineering. The ideal is profoundly wrong-headed, but it is also internally incoherent because ethnic groups cannot be sorted so as to give each a proportional share of social goods. There are just too many ways to cut the pie. The demand for racial balance imposes ugly costs. It entails some formal determination of the racial category to which each individual is assigned and some formal division of the spoils by group. It makes racial quarrels inevitable and rules, perhaps one drop of blood, for resolving disputes over ethnic membership essential. Claims are made by race, arguments by blood. No redistributive system could be more unwholesome. Who reaps the benefits and who bears the burdens of racial preference? The beneficiaries of race preference are a few members of the preferred groups, and the newly emerged core of administrators whose livelihoods are derived from the oversight and enforcement of preferences. The vast majority of the members of the minority groups in question, in whose interests preferences had purportedly been designed, they receive no benefits whatsoever. The burdens of preference, on the other hand, are borne by four large groups for each of whom the costs are very great. The cruelest and most damaging burdens are those imposed upon the members of the preferred minority group as a whole, who are inescapably undermined by racial preferences. When persons are appointed or admitted or promoted because of their racial group, it is inevitable that the members of that group will, in the institution giving such preference, perform less well on average. Membership in the minority group most certainly does not imply inferiority. That is a canard. But that stereotype is reinforced by preferences. Since the standards for the selection of minorities are inevitably lower when diluted by considerations of color, sex, or nationality, it is a certainty that overall the average performance of those in the preferred group will be weaker. Not because of their ethnicity, of course, but because many among them were selected on grounds having no bearing on the work or study pursued. Preference thus creates a link between the minority preferred and inferior performance. This burden is borne not only by those individuals preferred, but by every member of the minority group, including the many among them who genuinely excel. The general knowledge that persons with black or brown skins are given preference ensures lower expectations from all whose skins are one of those colors. Every minority member is made suspect. No one, including the minorities themselves, of course, can know for sure that any given member of a preferred group has not been awarded special favor. Skin color, the most prominent of personal characteristics, is thus transformed by preference into permanent and public onus. If some demon had sought to concoct a scheme aimed at undermining the credentials of minority businessmen, professionals, and students, to stigmatize them personally and to humiliate them publicly, there could have been no more ingenious plan devised than the preferences now so widely given in the name of affirmative action. Unfair burdens are also imposed upon deserving white applicants and employees who, because of their skin color, do not win the places that would otherwise have been theirs. One often hears the claim that the burdens of preferences are insignificant because they are widely shared by very many among the white majority already. This is false. Most among the majority bear no fraction of the burden. Those who do bear it are a small subset whose members are rarely identifiable by name. If a university gives admission preference to blacks, for example, some whites who would have been admitted but for that favoritism will not be admitted. The unfairness to those unidentifiable individuals who lose out because of their race is not reduced because we cannot learn their names, and every applicant with a pale skin who is not admitted or appointed may rightly wonder whether he was one of them whom the penalty had been exacted upon. Institutions that give preference pay a heavy price as well. Inferior performance results in many inefficiencies and hidden costs. In academic institutions, intellectual standards are lowered, explicitly or in secret. Student performance is unavoidably lower, on average, than it would have been without the preferences, as are faculty productivity and satisfaction. The political need to profess equal treatment for all while knowingly treating applicants and faculty members unequally because of their race produces a pervasive hypocrisy. Every great public institution hides their policies, describes them deceptively, and sometimes has to lie about them to maintain them. Part of the price of race preference is the loss of institutional integrity and public respect. Finally, society at large suffers from the distrust and hostility that race preferences engender. Members of ethnic groups tussling for a larger slice of the preferential pie come to resent and despise their opposite numbers and competing minorities who always seem to get more than their share of the spoils. In schools, in playgrounds, in parks, in commerce and sports, in industrial employment, even in legislatures and courts, the outcome is exacerbated tension, increasing self-segregation. More and more we come to abandon the ideal of an America in which persons and not groups are the focus of penalty and reward. Preference, ostensibly given to overcome the legacy of racism, takes the form of racism, nurtures racism, embitters the national community, and infects every facet of public life with racial criteria whose counterproductivity is matched only by its immorality. In the 1954 case of Brown versus Board of Education, Thurgood Marshall submitted the brief for the Legal Defense Fund of the NAACP, of which he was then executive director. He wrote there, quote, "Distinctions by race are so evil, so arbitrary and invidious, that a state bound to defend the equal protection of the laws must not invoke them in any public sphere." Close quote. The truth of this principle does not change with the times. Let us respond justly and compassionately to injury, giving remedy where remedy is due and credit where credit is due without regard to race. But if we are ever to heal our racial wounds, it will be through a national determination, morally resolute and backed by law where that is appropriate, never again to give preference by race or color or sex. The long-term success of a democratic polity requires a deep and widespread commitment to the principle that the laws protect all of us equally. In his controlling decision in Bakke in 1978, Justice Lewis Powell wrote, "The guarantee of equal protection cannot mean one thing when applied to one individual and something else when applied to a person of another color. If both are not accorded the same protection, then it is not equal." Is this so difficult to understand? We begin to transcend racism when we stop the practice of every form of it by every public body we know of. Citizens of the United States, black and white, in preponderant majority find skin color preference morally objectionable. Ours is a reasonably healthy democracy. Our body's politic will tolerate public discrimination, Not much longer. By court orders, by legislative acts, or by voter demand, race preferences will have to go. It needs to be replaced by its absence. I'm Seth Leibson. We'll be right back.